Welcome to the next episode of Off the Record with myself, Unati Dlamini, an associate in the Employment and Social Media Law departments of Shepstone and Wiley. Today, I'm joined by my colleague, Hope Mboweni, whose experience spans across conducting investigations to conducting disciplinary hearings for clients. Hope is also an avid runner, and whenever he gets the opportunity, he joins any race that he can. Hope, thank you so much for joining us today.
Good morning, Onachi. Thank you for having me. I'm happy to be with you today.
Thank you. So today, Hope is going to be taking us through discipline in the workplace. To kick us off, Hope, I'd like for you to explain what exactly do we mean by discipline in the employment law context?
So when we talk about discipline in the workplace, we're referring to the standards in which employees are required to uphold in the workplace. We often find these standards in employment policies, as well as the employees' contracts of employment. However, not everything has to be written in black and white. There are some standards that do not need to be written down, some things that include, such as the duty of good faith towards your employer. That's something that does not need to be written down, but it's an implied term to your employment contract as an employee. So those are some of the standards that you are required to keep. Most, like I said, you get them from your policies and employment contracts. Some do not need to be written down.
Okay. Now, you mentioned that discipline refers to standards that an employee has to uphold. So what happens in instances when an employee doesn't uphold those standards?
In most cases, if employers realize that employees have not upheld workplace standards, they would have to conduct an investigation into allegations that have been laid against employees. And if it happens that that particular investigation finds that there are merits to the allegations against the employee, the investigators might suggest that a formal disciplinary hearing be held against the employee. However, there are some allegations that are not so serious that will not warrant a disciplinary hearings. In such a case, those particular investigators will suggest that although the employee has committed an offense, but it's not so serious to warrant a formal disciplinary hearing, less measures may be taken by the employer.
Okay. So before we get to the formal disciplinary hearing, because I know that's a big topic, I'd like for you to just canvass what are those lesser measures that an employer can take in instances where the offense is not so serious for a hearing, but it's serious enough that the employer wants to deal with it.
Yes. So some of them could be a verbal warning.
Okay.
Some could be a final written warning, depending on what your workplace policy says. So those are some of the less sanctions that employers can follow without having to go through a disciplinary hearing. Obviously, an employee needs to be called and needs to be told about the allegations against them before such things are issued to them.
Okay. So now we've dealt with the lesser measures. Let's move on to what everyone wants to know about, the formal disciplinary hearing. So you've covered the investigation. So I'd say that's step one. So from the investigation, what happens next?
So from the investigation, if the investigation has found that there are merits to the allegations against the employee, that's when an employee is invited to a formal disciplinary hearing, which through something we call a notice to attend a disciplinary hearing. That's when an employee gets told what the allegations are against him or her.
Mm-hmm.
Case law states that the allegations against the employee must be precise. The employee needs to be told what is it that is alleged against them so that they can know what case they need to answer. There is no need to overcomplicate the charge sheet, but it has to be specific enough in order to allow the employee to answer to whatever charge or allegations are against them. Because one of the fundamental principles in employment law is to hear the other side. So the employee must be able to articulate himself through the charge sheet or to answer to the charge sheet that has been presented to him or her. And once that charge sheet has been given, the employer must ensure that sufficient time has been given to the employee in order for them to present a defense on the day of the disciplinary hearing.
Okay. So what is a sufficient time? Is there a specific time frame that we're looking at in terms of the law?
There's no specific time frame, but I would like to think about at least 2 days before
Okay.
may be sufficient to allow an employee to prepare his or her defense.
Okay. And how does an employer deal with an instance where the employee gets the notice to attend a hearing and they just like buzz off, I'm not going to attend that. I didn't do anything wrong.
So it's advisable for employees to attend disciplinary hearings, even if they believe that they didn't do anything wrong.
Okay.
Because like I've already stated that there's a principle in law that let the other side be heard. So when you get to a disciplinary hearing, that's where you state your defense that I did not do 1, 2, 3, 4, 5. Because if you don't attend the disciplinary hearing, you run the risk of the hearing being held in your absence. And if there's no evidence that you have led as the employee, then the chairperson of the disciplinary hearing is likely to find for the employer based on the evidence that's going to be before him, only if the chairperson finds that there are merits to what the employer has presented. So when you attend a disciplinary hearing, that's where you provide your defense that I did not do 1, 2, 3, 4, 5. But yes, so don't stay at home and not attend a disciplinary hearing because a disciplinary hearing will be held in your absence. However, before a chairperson does that, there are certain requirements that they need to tick off. One of them being that you were advised of the disciplinary hearing. And in most cases, chairpersons do wait for some time before they proceed with the disciplinary hearing to give you time to come and attend. And if after you've been given time to attend the disciplinary hearing, you still fail to attend, it will go ahead in your absence.
Okay. So we've dealt with the notice. Now, what happens on the actual day of the hearing? Who's there? Who's not allowed to be there? What is said? What shouldn't be said? Just take us through that.
So in a disciplinary hearing, there are normally 3 parties,
Okay.
being the chairperson, the initiator or the prosecutor, and the employee. So the chairperson is an external party who does not represent either the employee or the employer. The initiator or the prosecutor steps into the shoes of the employer. The prosecutor presents the case of the employer, and the employee has to present his or her defense to whatever allegations that have been brought against them. In some instances, there is an interpreter at the request of the employee.
Okay. So I know a lot of people may not be familiar with disciplinary hearings. So would you say a chairperson is almost like a judge in a courtroom?
Yes, in the strict sense, a chairperson is a judge because after having had evidence from both sides, the chairperson will go sit down and make his findings based on whatever was presented before him on the day.
Okay. And in terms of the parties that are involved, so you said it's chairperson, initiator, or prosecutor, and the employee. Is the employee allowed representation? Can they have someone to help them along if they say, well, I don't really understand why I'm here today. I don't understand the allegations. If it's a language barrier as well, how far can the interpreter get involved?
Yes. So the role of the interpreter, I'll just start with the interpreter. They are required to interpret whatever is said during the proceedings, what the chairperson, what the prosecutor, and what the employee states during the disciplinary hearings. In terms of representation, the employee is allowed to be represented by a fellow employee. And if that particular place is unionized and that particular employee is part of that union, they can request the union to come represent them. One question that we often receive is regarding legal representation by attorneys who are external parties to represent the employee. In the strict sense, lawyers are not required or not permitted to represent employees in disciplinary hearings because those are internal matters. However, employees are permitted to request before the chairperson to be represented by attorneys. However, it depends on what the policy says. Some policies do not allow for such applications to be made, but such applications can be made in certain instances. And depending on the complexity of the matter, the chairperson can grant such application for the employee to be represented by an attorney or anyone who's external.
So, with all of this in mind, Hope, as an attorney that assists companies, what role do you play in making sure that discipline is maintained in the workplace, and especially with ensuring that employers follow the policies that they have in place?
So, our role as attorneys in discipline in the workplace, we start off by assisting employers with drafting policies. We also assist with drafting employment contracts. When it comes to disciplinary hearings, we initiate matters on behalf of employers, and that will allow us to also conduct investigations into the allegations, because once we've conducted the investigation on behalf of the employer, we're now familiar with the facts of the matter, which will allow us to initiate or run the disciplinary hearing on behalf of the employer. We also step into the shoes of chairpersons from time to time. We can act as chairpersons, as independent parties that are outside the employ of the employer, and chair the disciplinary hearings on behalf of the employer to ensure that procedurally the employers are in line with the code of good practice.
Okay. Thank you so much, Hope, for joining us today. And as Hope has explained, maintaining discipline is not just going to be an express term in either the policies or the employment contract. It can also be implied terms, such as dealing with the duty of good faith. And it is important for employers to ensure that their policies are clear, and in instances where there is doubt, to call upon the expertise of someone like Hope to assist them from conducting the investigations to running the disciplinary hearings and assisting in instances where they need chairpersons. Thank you so much for joining us today, and we look forward for your engagement with the next episode of Off the Record.